Thank you for joining us this afternoon for our latest COVID-19 webinar. This afternoon's webinar is around returning to business and is entitled Update and Advice for Smooth Trading Post-COVID-19. I'm your chair this afternoon, Robert Cappo, and one of the partners here at Harris Scott Riggervis. I lead for us on COVID-19. I'm joined for this afternoon's webinar by Helen Higginbotham, who is a legal director in our corporate team, who specialises in corporate governance, and she's also a chartered company secretary. Helen's going to talk to you about best practice for corporate governance as we come out of COVID-19. We'll then have a presentation from Alex Wild, who's a partner in our restructuring and insolvency team based in our London office, and he's going to talk about directors' duties and how those play out over the course of the next few weeks and months ahead of us. And then finally Robin Colhoven, again a partner in our restructuring and insolvency team, and he's going to talk about stakeholder engagement and how to deal with that as we go forward. And then finally we'll wrap up the afternoon with a Q&A session. Thank you to those of you who have already sent questions in advance. We have a number of those. I'll also be keeping an eye on the Q&A facility through Zoom, so do please let your questions come in as the presentations roll. For those of you that have attended events I've chaired before, I normally like interactive events with Q&A as we're running, but unfortunately Zoom doesn't lend itself to that format, but we will make sure there's good time at the end to do Q&A and to take questions from you. So do please keep those questions coming in. So I'll hand over to Helen then for our first presentation. Helen.
Thank you, Robert. So, as mentioned, I will today be talking about corporate governance best practice and the changing landscapes in terms of how company law has changed in the wake of the COVID-19 pandemic. Next slide, please. So the first thing really is to think about is what is corporate governance? And there's various definitions floating around, but I like to think of it really as taking three core areas. We've got our board structure and decision-making processes. And when we think about board structure, we're looking at physical diversity and diversity of thought. And decision-making processes, this is about adapting to change and making sure we have flexible processes and clear decision-making. Then in terms of relationship and engagement with stakeholders, stakeholders obviously cover the breadth of interested parties, so employees and shareholders, making sure that they feel engaged in this time and kept up to date. And then finally, risk management, internal controls and policies, making sure that the company has contingency plans and understanding what the real purpose of the company is in both the long and the short term. So they are the three aspects, and I thought then we would touch upon a few points in relation to each of those. Next slide, please. So first of all then, the board. So now more than ever, I would say that it's important for the board to meet regularly and ensure that they make effective and efficient decisions. And how do they do that? And I guess there's a couple of options available to them. There's your virtual options, and then there's also written director resolutions. So in terms of the virtual options, most constitutional documents allow for meetings to be held by conference call or video conference, providing that all of the participants can hear and participate in the meeting. A word of warning there though, we need to make sure that the meeting is quorate throughout, not just at the beginning, but throughout the course of the meeting. So if somebody drops out of internet connection, that the participants are aware of that and that the meeting can continue. And therefore the chairman of the meeting is key to orchestrating and facilitating that process. The other alternative is written director resolutions, and these are normally passed when a unanimous decision is made, so on paper essentially. And of course, unfortunately, that doesn't allow for the opportunity of open discussion and dialogue. And then, of course, making sure that the board is kept up to date with developments. So, for example, as part of this COVID change in circumstance, we've had an allowance for an extension for filing accounts. So companies can make an application for a 3-month extension, providing that they make that application before the deadline. Also, there's some changes to how documents can be stamped, so stock transfer forms and buyback of shares. Gone are the days at the moment in terms of having a pretty stamp on a document. Now it seems that we have a letter from HMRC confirming that the correct stamp duty has been paid. And being mindful of electronic record keeping, so ensuring that the chairman can sign board minutes electronically, but also the registers can be maintained in electronic format, providing they can be printed into hard copy format if needed. And then finally, things are moving at a very quick pace. So for example, strike-off procedures, until last week, Companies House was saying that once the notice had been issued in the Gazette, they were suspending all further action. But now it seems last week that they've made an announcement that they will not suspend it if law enforcement partners have concluded that the company is no longer in operation. Next slide, please. So there were a few considerations really in terms of directors. Now we're moving to shareholder engagement. And the key thing here is how to make sure that they're kept informed and involved in the decision-making process. So we've got electronic communications with shareholders. So you can send notice of meetings or written resolutions by email or on a website of the company, providing that you go through a number and jump through a number of hoops in order to do so. So for example, for a written resolution to be circulated to a shareholder, you'd need that shareholder express consent to communicate in that manner and provide an email for that purpose. Whereas a company could be in receipt of a signed written resolution by either providing consent or being deemed to give that consent. But getting information to shareholders is key, and so that they're kept abreast of updates. Another hot topic at the moment is general meetings and AGMs. So there's been quite a lot of discussion in the marketplace in terms of how they can be held, certainly during the lockdown period. Now, it's worth remembering that a chairman can restrict entry into a general meeting when it's held physically to ensure the safety of the participants of the meeting. And the Governance Institute, ICSA, has recommended that actually, as part of the notice procedure for sending out a notice of general meeting, that it's made clear that entry will be restricted, and instead encourage shareholders to appoint proxies to vote on their behalf. And of course, the chairman and the company secretary could be appointed as proxies to vote on their behalf, and the meeting could go ahead in that way. I know that discussions have been made in terms of perhaps having hybrid general meetings, so some people present in person, or a physical meeting, and then others sort of dialing in or having some sort of virtual attendance. But the general rule of thumb to date has been that perhaps purely virtual general meetings may not be valid. However, it seems that that discussion has evolved, and we've got at the moment going through Parliament the Corporate Governance and Insolvency Bill. So it's making its way through Parliament at the moment, so it's not quite yet law, but it's one to watch because it's expected to come into force and be passed at the end of this month, but actually be backdated so that it takes effect from 26th of March, so the beginning of all of this. And essentially, the way it's drafted at the moment is that it covers a few key items of interest. The first being virtual meetings. And so the draft at the moment says that it will be possible for companies to hold general meetings and cast votes by electronic means. So that would be really interesting, especially given that it would be backdated. There's also a provision in there regarding AGM extensions to enable companies to postpone holding their AGM until the 30th of September, notwithstanding if there's anything contrary in their articles or in other legislation. I'm not sure how helpful that's going to be though, given that you may want to hold your AGM before that if you've got an authority to allot that's due to expire and you need to raise capital before that deadline. But hopefully the virtual general meeting will assist in that regard. And then finally, there's talk of giving the Secretary of State powers to extend Companies House deadlines during this time, which could be quite helpful in a number of circumstances. Next slide, please. So essentially, the final area is risk management, and this all really ties in together the points that I've touched upon today. So really, reputation of the company is key during this time, as we've seen various companies being reported on in the press. And really to ensure that the ethos of the company is maintained and its reputation is upheld, you need to make sure that the board is making effective and efficient decision making, that it's documented properly in terms of minutes, and the company has is run smoothly. When I've spoken to company secretarial colleagues in various aspects of the marketplace, they've said that actually what they found is that yes, there's more frequent board meetings that are being held virtually, but actually they're shorter meetings with more focus on the items on the agenda. And that's where, as I said at the beginning, effective chairing of those meetings is key in terms of having perhaps a timed agenda, allowing time for questions and to maintain that focus of the meeting. So perhaps that is a positive result out of all of this. And then communication, just making sure that you keep relevant, accurate and prompt information to both your board and your stakeholders. And then finally, making sure that at all times, and I know that we're touching upon this later in the presentation regarding directors' duties, but making sure that the board is acting in the best interests of the company, thinking at both the short and the long-term goals of the company, and ensuring that strategic plans are in place. So, for example, what happens if the chairman were to be taken ill? Who can chair the meeting in their absence? How do you adjourn the meeting? So a few thoughts for you there, but thank you very much for listening.
Thank you, Helen. A really useful overview there of the rules and guidance for company secretaries and corporate governance, and then some practical issues to think about too. So we'll now go over to Alex Wild. As I said earlier, Alex is a partner in our restructuring and insolvency team based in our London office. And Alex is going to talk to you about directors' duties and how they apply in the current situation. So Alex, over to you.
Thank you, Robert. Thank you very much. Good afternoon, everyone. Can I have the next slide, please? So, yeah, I'm going to be dealing with directors' duties, particularly in relation to the Corporate Governance Bill, which Helen has already mentioned. Hopefully some people will have noticed the press related to some of the changes to wrongful trading in the new bill. So where are we now? Last count, I think furlough accounted for something like a quarter of the workforce. More than a quarter of the workforce is now on furlough, 8.5 million people, a government liability of 12 billion or so. The scheme is shortly to close in July, and it's anticipated that over the course of the next 3 or 4 months thereafter, till October, there will be a gentle phasing out of furlough, with employers expected to pick up more of the slack. The funding schemes are still going strong. Over 15 billion has been lent to date, over 500,000 applications, not all successful, mind. Those are liabilities which need to be repaid, aren't gifted by the government, and long-term planning and short-term planning is going to be necessary to ensure that finances remain strong and that people trade out of their difficulties. It's fair to say that both of those issues and other issues are going to lead to a lot of hard decisions for directors moving forward. Employee retention is obviously going to be key. Whether the extent to which you continue to rely on furloughing, whether you rely to a certain extent on redundancies to slim down your workforce. I think we can assume that there will be quite a large number of redundancies in the near future. Health and safety for employees and customers is going to be paramount, as are arrangements with existing suppliers and customers who are also going to be experiencing their own difficulties. Much heralded by the government, Alex Sharma reported the changes to wrongful trading to great fanfare, and the quote is up there for you to read, suggesting that threat of personal liability for a director has now been removed. I don't think I'm giving much away at an early stage by saying that I don't think that's true, and anybody who understands or knows a bit about directors' duties and even wrongful trading will have seen through that comment almost immediately. There is no immunity from liability as a result of the changes, and people need to be aware of what the effects on wrongful trading are, and then what the other potential liabilities or issues might be. So if we can move on to the next slide, please. So yes, the Corporate Insolvency and Governance Bill, I would argue that it is not fit for purpose. The changes to wrongful trading, if you don't know what wrongful trading is an offence under the Insolvency Act that provides that a director will be personally liable for a proportion of a company's debts if he trades whilst insolvent, effectively. There are various intricacies to it, but that's the gist. What the amendments have provided is that for a period of no less than 3 months, which will have retrospective effects, like Helen said, a director will not be liable for any worsening of a company's position. The difficulty, even with the new amendments to wrongful trading, are that 3-month period could be shortened or lengthened. We don't know. That can be done using secondary legislation. So you can't even rely on that 3-month period particularly. And even the description of how the court should approach that particular 3-month period and the worsening of the position is not particularly clear, and realistically won't become clear until a few of these cases come before court and judges are allowed to expand on what the guidance was meant to mean. So I would argue that the changes provide you with no protection realistically at this moment in time. Other liabilities, the government unhelpfully did not detail or even consider giving details of other potential liabilities that might arise. To be quite frank, the number of them is quite astounding. The amount of content and legal analysis that I would be required to give you a true reflection of just how serious and these different offences are and how easy it is to fall into them, it could take me hours to expand on. But I've tried to put up there just some of the key ones for you to be aware of if you're not already. Obviously, the specific statutory duties under the Companies Act 2006, sections 171 to 177, provide that you should act with reasonable care and skill, that you should act to promote the best success of the company, avoid conflicts of interest, avoid transactions which you yourself have an interest in, amongst other different variations. Antecedent transactions are set out in the Insolvency Act and provide that a director can have liability if he enters into transactions, even if they are innocent and in the ordinary course of business, if the effect of those transactions is to put certain creditors or individuals in a better position than other creditors. So that is something to always bear in mind in relation to directors' duties. And then finally, one of the key issues that I think everyone involved should have some consideration of is what's called the twilight zone, the common law duty during the twilight zone. If I go to the next slide, please. So these are the two that I will concentrate on for the most part, just to try and give you a view on just how wide-ranging these two in particular are and how you need to have regard to particular issues and interests just in relation to these two issues. So the duty to promote the success of the company is, I think, section 172 of the Companies Act. That duty in itself is subdivided into categories of interests and issues which a director should have consideration of at all times. These include having regard to the interests of employees, having regard to the interests of creditors, of customers, of suppliers, of shareholders, of the community, of the environment. It's a non-exhaustive list. There's about 7 or 8 of them. And I think you can tell just from that short analysis that it covers pretty much anything and everything a company might affect or have a role in managing. The duty to promote the success of the company includes a duty to have regard to the interests of creditors, and that interest is activated when a company is deemed to be insolvent or in the eyes of the court when it is deemed to be likely insolvent or probable that it is insolvent. As you'd expect, there is a lot of case law around what likely and probable means. The very worst analysis being if you consider that there was a 51% likelihood of a company being insolvent. That means 2% more than 49%. It is more than probable, therefore, that there might be an insolvency in the company's future. Hopefully you can see that a company during this particular climate could quite easily be found to have a risk of becoming insolvent in the near future. So the question is always going to be, how can we manage the interests of the company to safeguard the interests of creditors and to ensure that the directors aren't incurring or accruing any potential liability at some point in the future. If I can move on to the next slide, please. So I'll try not to go into too many of the practicalities in too much detail, because Robin, my colleague, is going to be dealing with them in a lot more detail. But it is fair to say, and I think it's something that Helen mentioned as well, record keeping and communication is going to be key. I think the idea that anyone in a position of a director or similar should have in their mind that when the company is entering into any large transaction in particular, particularly any transaction with an associated party, with a director, with a shareholder, any transaction which has the effect of putting one party in a significantly better position, or as a result of a series of transactions, one party or creditor in a significantly worse position, that they need to be considering what the rationale for that is, what the commercial reasoning for that is, and then documenting that very carefully so that it can be produced at some point in the future if, God forbid, further issues come up further down the line. So record keeping, increased communication can be very important. We suspect that solvency issues are going to be something which the vast majority of companies are going to be dealing with. If it isn't something which they're experiencing currently because they have the benefit of financial support, it might be something they experience in the short term, as we can expect, we suspect, other companies within your supply chain or within supply chains to experience their own difficulties and then have knock-on effects. So maintaining financial reporting and considering monitoring your own supply chain and customers, etc., is going to be very important. Employee consultation processes, case law has already shown us that it's important to carry out a thorough consultation process, not just in relation to redundancy, which has always been a well-established norm anyway, but also in relation to furloughing, because at some point in the future there may come a time at which you're going to have to explain why you made certain categories of employees furloughed, and some were redundant, some were then released and made redundant, some were put back on furlough, etc., etc. There may be a whole chain of transactions or employee-related decisions which need to be explained. And then very finally, I would say, with my time running short, that avoid, insofar as possible, transactions outside of the ordinary course of business. I think everybody should be treating the next 3-6 months as a period in which we stabilise, steady the ship insofar as possible, and stick to the core business, consolidate and build thereafter, and avoid large exceptional financial transactions in particular. So yes, hopefully you can see that there is a lot to consider for directors during this period. I'll try to give you a brief overview, but hopefully we're going to have time for some questions at the end. So I'm looking forward to a lively discussion about various of the issues.
Thank you, Alex. Really interesting overview there of how the insolvency rules are all changing and how they're going to be applied over the next few months and no doubt years. Alex talked there about questions. Do keep the questions coming in. We've got some, and we'll be picking up those after Robin's presentation. So Robin, if I can pass over to you, you're going to talk about cash flow and how that sits in the current situation. So Robin, over to you, please.
Thanks, Robert. Good afternoon, everybody. My name is Robin Coolhoven, a partner in the Restructuring and Solvency team. We've heard some very interesting points made in respect of corporate governance and also in respect, obviously, of the matter of directors' duties. We're going to talk now about interacting with your stakeholders and talk about cash flow in particular. So if I could have the next slide, please. Right, so what's quite obvious is that we are about to enter a phase of business which is very different to anything that many of us have encountered before. We're going to have to talk about improving cash collection, and that means we need to communicate better with our stakeholders. In this sense, the stakeholders I'm talking about are the people such as in your supply chain, your customers, but also your logistics side, and all parts of your business in reality. Now, it's easy to say that ideally what we'd like is cash on delivery, but the reality is nearly all the businesses that we're talking with and doing business with are going to be in exactly the same boat. Everyone's going to be looking at either delaying payment or seeking extensions of credit. And we have to be careful here. We need to be carefully about not extending credit. We need to think about revisiting our terms and conditions to ensure that we have as strong a position in contract as we can do. I put on this slide retention of title because in reality, retention of title has a lot to do with your control of cash flow because it allows you to recover those goods you've delivered if you've not been paid. So it's important to have a think about your terms and conditions and in particular the retention of title. Above all, actually what we should be doing and what hopefully a lot of businesses have been doing over this period is trying to understand their customer better, doing the necessary credit checks, speaking with other suppliers and comparing experiences that those suppliers have because information is absolutely key to making sure that we don't extend or worsen the position or the relationship we have with creditors or with customers on a cash basis. It's also about educating our staff on key outgoings so that they understand what is important and what is not. And although it's slightly counterintuitive, effectively, we want to extend the period over which we make payments out and shorten the period over which we get payments in. In reality, of course, that's what pretty much any business is going to be doing in these circumstances. Next slide, please. So, as Alex mentioned, we've had some pretty useful help from the government in terms of the furlough scheme, but that is now a decreasing benefit. And also we've had a lot of useful cash flow tools such as CBILS to give people the necessary capital to carry on trading. However, as I've put there, these are just useful but temporary fixes. CBILS will have to be repaid eventually, and any arrangements we've reached with government agencies and the like will of course be temporary fixtures because payment holidays are exactly that. They are payment holidays and they are not an instant cash flow fix or anything other than an instant cash flow fix. Next slide, please. So what I think is that what we need to be thinking about is rethinking and revisiting our business when we talk about our future cash flow. The order book, for instance, can we realistically expect it to be at the levels that it was pre-COVID-19? And if we can, how long will that take? In terms of staff, what a lot of businesses will have learned is that the furloughing scheme has actually enabled them to rationalize the levels of staff they may require. And there are a number of businesses, for instance, that I'm currently advising where the staff levels are going to be critically altered in order to enable the business to survive more healthily. It's important to renegotiate with your landlords and your lenders, but not in terms necessarily of payment holidays, which are temporary fixes, but actually look in the case of landlords at whether you require the space or whether you can negotiate a reduced rent, not on a temporary basis, but on a permanent basis. For those businesses that will have been considering expansion pre-COVID-19, it's very likely that those expansion plans will have been mothballed. And in fact, that is probably the right thing to do. It's not the time now to spend major capital. It is better to assess what other opportunities might arise, because I believe that when you assess the sector and the market generally, that over the next 6 months, we'll see an increase in stressed businesses which will become available for the purpose of merger or purchase. That may be businesses which complement your existing business. It could be businesses which actually allow you to expand into other areas that you currently outsource, such as logistics. And of course, there's always the opportunity to consider cash flow options such as asset-based lending and invoice finance. Asset-based lending in particular, not just in relation to sale and leaseback of real property, but also of large pieces of equipment and machinery. And invoice financing has become, of course, increasingly sophisticated. Next slide, please. But cash flow is important for your business, but it's also important, as you've heard from both Helen and from Alex, that you protect yourself. And then it's not for me to repeat what's already been said, but it is exceptionally important for you to consider your duties throughout. And remember, in a situation where there is a greater likelihood than not, and for that example, use Alex's example of 49-51%, that you seek advice in a situation where you have a cash flow difficulty and therefore more likely than not run the risk of a potential insolvency. Both Helen and Alex talked about the importance of minuting your decisions, but I would go a little bit further than that, and I would say that it's important that you also set out the reasoning behind those decisions. Don't be afraid to make sure that the minutes are fully comprehensive and explain not only the thinking behind it, the discussions, but the reasons that the conclusions have been made, because that's essential to show that you as a director were seeking to act in the best interest of the company, or in the event that there is a real prospect of insolvency, in the best interest of the creditors of the company. And essentially, as always, you've got to keep proper books and records. And I'm not just talking about the financial records, I'm talking about all records, all decisions made, and the reasoning behind it. But above all, and I think this would be my final point, communicate with your customers, your suppliers, and your competitors, because knowledge is of real value in a circumstance where we are about to enter a completely different phase of business, something that is a little bit of an unknown to all of us. So cash flow is important, knowledge is important, but communicating with all your key stakeholders is going to be absolutely essential to get you through the most difficult times. And that's all from me. Thank you.
Thank you, Robin. A really insightful view there of the practical issues that lots of businesses are going to face over the weeks and months ahead. So thank you very much for that. Let's turn now to our questions this afternoon. Our first question for Helen. Helen, from a corporate governance perspective, what do you think is the key takeaway from your presentation this afternoon that attendees should be conscious of tomorrow morning when they're sitting behind their desks?
Thank you, Robert. I think obviously we've seen a real shift in terms of how boards are making decisions, in terms of having telephone conference or video conference in order to meet and make decisions. But it seems to me that those meetings are more frequent, they're less paper heavy, so the board packs have massively reduced. But it also means that those meetings are much more focused. So I think that's a positive result. What I would say though, in terms of things to think about, and I think this is the responsibility of the chairman of the meeting, but also the company secretary or the clerk, is to make sure that all participants on that board are comfortable with the format that is being used and the medium. So it may be that actually when you have people physically present in a meeting together, that actually it allows for more open discussion and more open challenge because people are more confident in that forum. So probably just something to be mindful of to make sure that, like I say, those discussions are free-flowing and that decisions can be openly challenged if they need to be.
Okay, thank you for that, Helen. Alex, I would turn that question over to you as well, actually. What do you think is the key takeaway for attendees to be conscious of tomorrow morning when they're sat behind their desks and they're pondering the latest insolvency laws?
I think the key to me is just this understanding that we're in unparalleled times. So whatever, most company directors, especially for small, owner-managed businesses, will be confident in their business proposition. They will think, I've run this business for 5, 10, 15, 20 years. They will think I've weathered previous crises before, I'll weather future crises, and I'll weather this one, which is hopefully true in the vast majority of cases. but I would caution them not to be too foolhardy, and just to, for the next 3, 6, 9, 12 months, whatever it may be, consider carefully and make yourself aware, if you're not already, in greater detail of the potential risks, potential liabilities, and then plan would be my takeaway. There are easy things to avoid, and one of the key ones which everyone should be aware of is during this period of austerity, if you are making large percentages of your workforce redundant and creditor liabilities are accruing and increasing, that is a warning sign. If you are simultaneously withdrawing large sums of money yourself on account of dividends or your own salary drawings, whatever, then these are things which commonly are commented on and criticised subsequently if the companies go into liquidation. So it is very much a period of tightening your belts and planning for the future.
Okay, thank you. And Robin, perhaps no surprise, I'm going to ask that question of you as well. What do you think is the key takeaway for people tomorrow morning and be thinking about when they're practically thinking about the stakeholders and their cash position and how their forecasts are coming together?
Well, essentially, I think, as Alex has alluded to as well, there's an element of guesswork involved here as to how quickly a business is going to recover. So I think it's communication. For me, it's very important that they consider their duties, that they understand the risks involved, but also that they communicate with their stakeholders. Because if you're communicating with those people that are effectively in your financial chain in one form or another, then at least you're addressing the issue. What not to do is simply keep your head down and hope that people won't chase for money, because everyone's going to be in the same boat. Cash flow is going to be extremely difficult in circumstances where an awful lot of businesses have mothballed either the whole or part of their operation. So while they may have survived with furlough and CBILS and some government assistance, there is going to come a period, probably in the next 3 or 4 months, where there will be a complete and utter lack of cash in those businesses. And that is likely in certain sectors to be right across the sector. So that cash flow is going to be a real issue. So it is about communication. It is about availing yourself of the opportunity to get assistance where you can from banks and from landlords and things, but also recognizing that that is a temporary fix more often than not. So I've come across an increasing number of landlords, for instance, which are expressing a greater desire to, rather than give payment holidays, actually reduce the rent in order to assist, because the longer term picture is bigger for them than putting their tenant at risk. So communication for me, the sort of very sort of lucid points that Helen and Alex have made.
I think that's an interesting point there. The landlord example, there's lots of landlord-tenant discussions going on at the moment, and landlords and tenants agreeing forbearance. A question from Mark Taylor asking about seeking to make a permanent arrangement with landlords. How is that best framed with a landlord, and what approach would you suggest take to that discussion?
It's going to be difficult, isn't it? Because it's going to depend on the landlord. I think certain landlords will be certainly investment type landlords will be much more seeing that their income is going to be very largely dependent on the strength of the economy and of the business of their tenants. Other landlords will be more difficult, and I think you have to look at it from a there's no set way of approaching any of these things. I think you're going to have to know your landlord well, and I would have thought the starting point is have a sensible sit down with the landlord at the outset. And I think the first point is don't be afraid to be very open about the financial difficulties faced, but explain to the landlord how those financial difficulties, that it's a genuine test with genuine information. The kind of the more general, are you seeking to take advantage of the situation? And unfortunately, there are also instances of that. So it's important, I think, to be prepared and accept that if you're going to ask a landlord for forbearance or for a rent reduction, that you can show a genuine business reason for it. and be prepared to provide perhaps a bit more information than you might otherwise have expected to.
Okay, that's helpful, Robin. A wider question really from Mark Taylor as well there. How do you think that conversation plays out across a whole range of stakeholders? How would you best position those?
Well, it's not dissimilar really, in the sense of it depends very much on the nature and the strength of the relationship you have with the stakeholders. I think the vast majority of businesses, particularly depending, on the situation where, for instance, you are a very large part of their turnover or a substantial part of their supply chain, the vast majority of businesses, in my view, will take a pragmatic approach. But there's a massive difference here between this sort of concept of a payment holiday and an actual, if you like, either a debt forgiveness or a variation of the existing contract. I think a payment holiday is a temporary fix, and while I don't want to suggest that it's not helpful, it does have to be addressed in the future. The difficulty in these circumstances, you don't know how long it is going to be before you get to the point where you can address that. So it's a question of, are you then robbing Peter to pay Paul? Whereas I think a variation of the contract for good commercial reason, if you've got the right kind of strength of relationship with stakeholders, is obviously much more beneficial and is likely actually to help strengthen the relationship.
Okay, good. So a scenario put by one of our attendees this afternoon, but anonymously, they're a director of a charity, and they want to know what steps they should be taking to ensure the charity is a viable concern going forward. I think that's a useful question probably for all three of you. So Helen, what advice would you be giving the CEO of a charity at this time?
I think this comes back to the point in terms of making sure that records of decisions are thorough in terms of meetings that are held, but also why that decision was reached. And I think Robin's talked about that as part of his presentation as well. It's just making sure that you've got that full record in terms of how those decisions were reached, how confident are they in terms of making those statements. And it comes back to the point that I raised in terms of making sure that your stakeholders are kept informed during this trying time. And I can see that various companies are dealing with that in different ways. So whether that be by podcast or Q&As on a website, just to make sure that information flow and reassurance is there at all levels.
Okay, thank you. And Alex, what would you be advising the director of a charity at this time?
I think cash flow is probably very important. I think financial modelling and monitoring exactly what your income expenditure is over the next 3 to 6 months, what liabilities are going to come up, the extent to which you can pay your debts as and when they fall due over that period, which is, in the context of a trading company, quite a short period of time, especially when there's so much finance and government support around, is going to be key. Some people will look at a balance sheet and say, oh, we've lost our largest customer, we've lost our largest contract, we have these long-term liabilities, which makes it look like we're insolvent. But there's more to the analysis than just assets versus liabilities. It is very much, can you pay your debts as and when they fall due? I suppose the idea, we hope, is that this is just a short-term blip and that we'll all return to the same levels of turnover and productivity that we were prior to the pandemic. And it's just monitoring those finances as time goes along. Some people will say that there was no reason to make amendments to the wrongful trading provision because one of the key defences to wrongful trading is what's called the blue sky test, which is if you have reasonable belief that your company will trade through its difficulties and will return to profitability at some point in the future, then that is a sufficient defence for continuing to trade even when you're insolvent. It comes up in almost every wrongful trading case you ever look at, and you find it difficult to find a better set of circumstances where that might apply. You had a perfectly good, viable business prior to this situation, short-term blip, and you hope that it recovers at some point in the future. The people who really need to give this some serious consideration are those people who already had financial difficulties before this kicked off, and this has just exacerbated it. If you already had financial difficulties that you're aware of, that you were monitoring, and then this has made things worse, that's when you might need to make some more serious decisions and some more serious consultation.
Okay, thank you, Alex. Then Robin, last but not least to you.
Well, apart from everything that's already been said by Helen and Alex, the reality is charities like no other business in the sense that it's going to have to look at, where are its inevitable problems, and its inevitable problems, I think, in the current climate is going to be where is it getting its income from. So it's identifying those sources of income which are most at risk, and then possibly looking at what reworking or restructuring or rethinking needs to be put in place to try and address that and combat the inevitable effect of a downturn in the income stream. So no different to any other business. And the one thing I'd like to add to what Alex said was that while Alex and I obviously from time to time in our work do come across a number of errant directors, the reality is that 99.99% of directors are honest, hard-working people who are doing their absolute level best for their business, for their employees, for their stakeholders, and have the interest of everyone at heart. And the reality is these people are now being tested like they've probably never been tested before, because this is not something that anybody could have planned for. And as I said earlier, a lot of people have mothballed their business, and so it's just trying to work out how quickly you can get back that business. So, but charity is no different to any other business in that sense. It's got the same sense of duties. It's got the same things to think about, yes, and it's going to be interesting but sobering times, I suspect.
I'm sure that's right, Robin, for all sectors of the economy. Robin, a related question again from Mark Taylor, who's kept us busy this afternoon. What happens if you're in a sector where you can't gauge the return, and you're almost having to run multiple tracks about where you think levels of demand are going to be at, and then at the same time, then of course running multiple conversations with staff about who may or may not be furloughed and who may or may not be made redundant? What's your advice about how to manage those stakeholders?
Well, first and foremost, if you're communicating with the stakeholders, whether those are your shareholders, employees, or your business stakeholders, such as suppliers, etc., as long as you're communicating with them, that's the first thing. That's the important aspect. I think secondly, the reality is that the vast majority of businesses sometime in their life cycle could potentially be said to be at risk of an insolvency event, because all businesses will have cash flow blips from time to time, will have situations where assets are exceeded by liabilities. It doesn't automatically follow, and this is very much following on from the blue sky test, as Alex explained. It doesn't follow that doesn't mean that you can't trade out of those difficulties. And I think a large part of the wrongful trading comments made by the government were aimed at actually trying to put directors' minds at ease about, look, we understand there is a difficult situation and you will need time to trade out of it. There's no doubt that it's, we are, to a degree in terms of business, we are having to guess where the market might be. And that, in reality, if you consider that the majority of non-essential businesses will be opening next Monday, that process starts then. And actually it's going to be anything up to 6 months to get a proper understanding of where that market really sits. The problem for directors is that they continue to have a duty to their company, but also have a duty to the creditors. So they will have to reassess on a regular basis. And my advice for anyone that is uncertain is seek advice. And I say that not from the point of view of seek advice for the sake of seeking advice, but actually seek advice because it shows that you are addressing the situation and taking the steps that a reasonable and honest director would want to take in the circumstances. But I entirely accept Mark's question's a really good one, and there is no ideal clear answer at present. Okay,
thank you for that, Robin. That actually concludes all of our questions this afternoon. So thank you to the panel for answering those, and also thank you to the panel for their presentations this afternoon, which gives a wide overview of the issues that businesses will face as they start to get back to business. thank you to our attendees this afternoon. They will all receive an email in the next few days with replies to all the questions, at some point as well a link to this presentation this afternoon, so they have that for future reference. You'll also have a link to some corporate governance resources produced by Helen Higginbotham, and as well as that, some FAQs from our restructuring and insolvency team. For those of you that are following our webinars at the moment, our next webinar is on the 20th of June, and very much moving forward and looking at the future of work as our offices and factories and shops and workplaces start to reopen. But with that, if I can wish you all a good afternoon, and thank you very much.